Good afternoon. We're here to receive comments from case 9449, the AltaGas WGL merger related to the Most Favored Nation Clause, condition 52. I really appreciate all the parties, particularly the company, for how rapidly you filed this MFN filing, and also for all the parties for quickly also providing their comments as well. It appears from what has been filed that there is general agreement on the overall amount that we're talking about, $3,878,034.85, and just a discussion here today on how it should be allocated or how it should be spent. So the way we've organized it, we'll have two panels. The first panel is already at the table with AltaGas, WGL, and MEA. And then we'll have a second panel with, I understand, representatives from the Department of Defense, FEA, OPC, and our staff. So with that, why don't we go ahead and take appearances at the table, and we will go ahead and let you decide how you want to, arrange yourself. I'm guessing the company would go first, and then we would hear from MEA. But with that, please.
Just for the record, Your Honor, Joseph Curran on behalf of AltaGas here today. I'm also joined at the table with my colleague Don Hayes from Washington Gas, as well as Mr. Jim Wagner, who is the Director of Rates and Regulatory Affairs for Washington Gas, and quite frankly are here to answer any questions you may have about our filing, as well as the filings from the other parties.
Very good. From MEA?
Good afternoon, Commissioners. My name is Annika Schneier on behalf of the Maryland Energy Administration, and with me is Richard Mallory, also Program Manager for MEA, and he'll be doing the bulk of the conversation regarding our position.
Great, very good. And I also invite my colleagues to go ahead and just chime in with your questions as they may come to you, and we'll go ahead and get started with WGL.
Yeah, just very briefly, Your Honor, I think you hit the nail on the head. There's general agreement from what we've discerned from the filings on the amount of additional funds that are coming to the state of Maryland as a result of our settlement in the District of Columbia, as well as the commission down in the district approving the merger and our settlement back in June 29th. And as a result, we had our filings in both August and in October that set out in Exhibit B how we did the calculation. Staff and the other parties have had an opportunity to review that, and I think there's general consensus that that is we've done the calculation correctly. I know that OPC also referenced it in their comments that they would have preferred a different MFN calculation, but and I'll be happy to address any questions regarding that if they continue to raise that point. But I think essentially we're all parties are agreeing on the amount. There is some dispute on how to allocate those additional dollars. We tend to agree with the Maryland Energy Administration that based on really the settlement that we entered into, and then ultimately the Commission's review of that settlement and the final adoption of our order back in April, that the most appropriate use of those funds would be to allocate them to the Maryland Gas Expansion Fund. And I certainly let MEA talk more about their plans for that. But if you look at the order, the character of the testimony that was filed on the environmental benefits, the jobs benefits, and other externalities that we presented during the hearing, that and certainly consistent with Maryland's attempted public policy of expanding the natural gas system in the state, we think the best use of those funds would be directed towards MEA's use in the for infrastructure investment here in the state. The only thing that we would add, I know some parties were suggested that perhaps it would be useful to use the dollars for rate credits or rate offset. And that's certainly within your discretion to use it for whatever you deem in the public interest. However, we think that the highest and best use would be to invest those dollars in infrastructure. And for the reasons that you all identified in your order approving our settlement and the merger. But more importantly, it's a good use of those dollars, and we would be excited to to use them for those purposes, and hopefully that you would give strong consideration to doing that. And then I'm obviously happy to answer any questions you may have today about either our calculation or the use of these additional dollars for Maryland.
Great, thank you. Do we have any questions at the time? Commissioner Herman.
So, Mr. Curran, you agree that it is not required that the commission provide these dollars to the natural gas expansion?
I would say
believe you
that
said
your
that.
I would say your order has two pieces. One, that it be used in the public interest, but also that we would consent, that AltaGas and the applicants would not object to consenting to an order to use those dollars for gas expansion. So certainly with the intent when we settled with MEA to use it for gas expansion and for energy efficiency, the Commission, in reviewing our settlement, elected to take out the provision on energy efficiency and focused on gas expansion programs, but also has a clause in there that will be used for the public interest. So ultimately, you all are the deciders of the public interest, and in effectuating your orders, we think that the best reading of it is that the dollar should be used for gas expansion programs. We think that those programs are in the public interest, and the best use would be for the fund itself.
Right, but if the commission is not prohibited from choosing, for example, as some parties have suggested, if the commission wanted to do a rate credit, that's not, that the commission is in its, has its authority under the second provision by saying that the MFN dollars can be allocated in any manner that's consistent with the public interest if the commission
Correct.
were determined that the public interest were a rate credit.
I absolutely, Commissioner Herman, I agree with that reading.
Okay.
And then the only thing that we would add to that is when we saw that the parties were interested in a rate credit, we ran the numbers and determined that the $3.8 million would amount to about a $6 rate credit for customers, and said, hey, is that the highest and best use of these dollars? Probably the Commission was right when it agreed with the highest use, the best use may be for gas expansion programs.
Right, and if that $6 allocation, and maybe Mr. Wagner might want to take this, is that $6 allocation an allocation of the $3.6 million all to residential or to residential and non-residential customers?
Commissioner Herman, it would be a combination. So it's of the 3.8 million, based on how the initial 30.5 was split, it's allocating it that same way. So subject to check, in the neighborhood of 2.8 million of it would go to residential and be spread among existing residential customers.
Okay, thank you very much.
Commissioner Lipton?
Thank you, Mr. Chairman. For MEA, your recommendation, of course, was to direct the money to the Maryland Gas Expansion Fund. Could you give us a little update on the status of the funds that are there now and the operation of MEA's use of that fund?
And Commissioner Lynn, maybe, did you have an opening statement that you wanted to provide, or?
It was nothing substantial.
Okay.
But
Sorry about that.
For the opportunity.
I never recognized them. So.
Commissioner Linton, I will make a brief remark if I can return to your question, please.
Sure.
MEA wants to echo the sentiments that the applicants have put forth. You got it. MEA would like to echo the sentiments that the applicants put forth. We are very pleased to see that there is no dispute over the algebra involved. It saves us a bunch of resources and is definitely in alignment with our agenda for finding a consensus amongst a diverse group of stakeholders. We're also excited to be here today. We worked very hard to come to a settlement agreement with the applicants and the other settling parties, and we were very pleased with the results that came out in Order 88631. Commissioner Linton, I think that's a terrific question. MEA has had meetings with almost every investor-held regulated utility in Maryland regarding the future of MGEF and what they think the best policies would be to help them efficiently use those resources to expand the footprint of natural gas in Maryland. We've met with stakeholders beyond investor-owned local distribution companies for natural gas. As our comments indicate, we're ready to announce that a significant portion of the program's first year will be dedicated to workforce development. That was a consistent theme we heard from the regulated utilities, that one of the hurdles they face to putting new infrastructure in Maryland, piping in the ground and assets above it, was the lack of a skilled and ready workforce. MEA also has experience giving workforce development grants. We have an existing memorandum of understanding with the Department of Licensing, Labor, and Regulation, and feel that, in addition to some other programs that we've been discussing internally and with other stakeholders, would be the best use of the resources.
Commissioner
Do you
Herman?
mind? I have some questions about that. When you say the first year's expenditures, are you talking about the $30 million from the settlement? And I'm generally, I know it was 30 million and
I believe
And more.
800,000.
yes, and but I'm just going to call it the $30 million portion of the fund for the Maryland gas expansion. Is that the MGEF?
That is the MGEF.
For the court reporter, that's Maryland Gas Expansion Fund. You caught me with the G versus a J. So
We have the same controversy internally.
So, how much of the fund do you expect to expend on workforce development? And in your view, is that consistent with the settlement that says that it should be spent on natural gas infrastructure expansion?
Commissioner Herman, that's a fantastic question. We believe that it is consistent. The language that came in the settlement agreement and that made its way into the order is to promote natural gas development. We would like nothing more than to spend this on commodities such as piping and equipment such as excavators. And we were also pleased to see that the Commission put in safety training for, excavators into 88631. But it is a central part of the governor's agenda to engage in workforce development and to take care of our people in terms of getting them as jobs as efficiently as possible. And when we heard a consistent theme from LDC companies that one thing that they need in order to help get the infrastructure in place, licensed in the ground, and safely installed and operated was a larger, better workforce, we were very eager to engage in that conversation and to start taking steps to make it a reality. There's also not an economy of scale, but we believe another economic efficiency where MEA is already developing workforce development programs as a part of resources that we've obtained through other settlement agreements here before the PSC, particularly with offshore wind. We have a large workforce development program that we think can, sort of piggyback off of the MGEF expenditures in that regard. And it is, in our opinion, very good public policy when those benefits go towards enhancing our human assets. Those human assets take that benefit with them for life. Not just across excavator operation in Calvert County, but then if they need to go do the same or perhaps some plumbing in Allegheny County, that worker has that asset with them for life. They've been trained on safety and on the technical skills that gas expansion demands.
So I have two additional questions, and I'll let my colleagues ask some questions as well, of course. But part of the settlement is that the majority of the funds are to be used in Washington Gas's service territory. So how, if you're using it for workforce development in lieu of infrastructure construction, how can we be assured that the majority of the funds are spent in the service territory?
Commissioner Herman, that is another excellent question that we've debated internally as well. For ease of accounting, our plan in that regard was to account for those funds where the training takes place. Dollar has facilities in Charles County and in Wicomico County where those sorts of workforce development programs can take place. So we would consider the Charles County Training Center any resources which Dollar can track through our Memorandum of Understanding. We'll have to develop another one, but we feel it will be very similar with the one we currently have in place. The situs of where the training takes place would control, for accounting purposes, on the restriction that the majority must be spent within the service area.
Mm-hmm. So I guess, part of my confusion lies in that we've had Washington Gas here a number of times, I believe recently with their Stride expansion plan and in their most recent rate case, where they've said they would have no trouble obtaining and getting resources for their expanded Stride program. So I guess I hear you saying that LDCs don't have the necessary personnel, but I hear BGE and specifically Washington Gas, which is what we're concerned with, which is the company that is at issue here, saying that there are enough people there on the ground now to expand Stride. So those two things appear to me to be inconsistent. Can you help me out with that?
Commissioner Herman, I wish that I could. I have not stayed abreast of the Stride 3.0 proceedings, and I wouldn't want to speak for the LDCs and testimony that they've offered before the commission.
So, I mean, have you, is it, I don't want you to, if you're having confidential negotiations, but, I believe, and, Mr. Hayes can help me out, that Washington Gas has not expressed a concern with the ability to have sufficient people to do its current plans and its future plans. Is that correct?
That's correct, Commissioner Herman. That was the testimony in the Stride 2 hearing several weeks ago. I can't remember if it was Mr. Stabler who indicated that Washington Gas could add contractor crews to increase the workforce to do the gas replacement work for Stride. So,
right. So is Washington Gas having these kinds of issues? It doesn't sound like they're having issues hiring, workers sufficient to do the work that they need to do.
Based on Mr. Stabler's testimony in the Stride case, that's correct.
Right.
I believe
So I
that's
guess
correct.
that goes back to my at least 50, assuming that there were agreement that using it for workforce development was consistent with the terms of the settlement. That goes back to how can the commission be sure, because the training takes place, but the fact is how is it, this whole reason that was put in there is so that Washington Gas customers benefited from that. And so how can, because people are being trained in Charles County, they may go and work in another county. How can we be sure that the benefit is being maintained in Washington Gas's service territory?
Commissioner Herman, there is no way to, with a high degree of certainty, guarantee that it would stay in the service area. Labor, by its nature, is transitory, but we feel that it is a prudent investment to make from a policy perspective. I apologize, if I've caused confusion. It may not, WGL may not have specifically expressed to us during our meetings that they needed, a greater amount of human resources. But MEA's policy position is that workforce development grants would assist with the expansion of natural gas service in Maryland. And we agree there, it is a challenge to account for how a majority of those benefits would stay within the WGL service territory doing any sort of workforce development, be it in Charles County, Wicomico County, or Frederick. And we hope that the commission will consider that a stronger, better trained workforce that has safety ingrained in it will assist with natural gas development statewide, because a minority of the benefit is a statewide benefit.
A minority.
Less than a majority.
Right.
The order makes clear the majority of the resources have to be expended within the WGL service area.
Right. And just to finish out, you would agree that if, for example, part of the funds were used to build natural gas infrastructure in southern Maryland and Washington Gas service territory, that would clearly be a benefit, or it would be a spending. We would know for sure that those funds were being spent in Washington Gas service territory, right?
Absolutely. I mean, the good news about infrastructure assets is that it's a lot easier to do the situs of the asset test.
Okay.
I believe, I'm sorry, Mr. Nair may have something to add.
I just had one point that came to my mind, which was that assuming the commission So, assuming that the commission wanted to put the money towards workforce development, how you determine or classify that as being in service or out of service is something that you would still have a choice in allocating in terms of, however you choose to disperse the funds.
I'm not sure I understand what you mean by in service or out of service.
Well, according to the order, a majority of the MGEF or MGEF is supposed to be spent within the service territory.
Oh, inside the service
Inside the
territory or
service
outside the service territory. Okay.
So how you classify workforce development funds could be earmarked as money that's going towards outside the service territory, and so you could put that similar restriction on how much of it can go towards workforce development.
Okay.
And
So,
if I may add one matter, Commissioner Herman, I apologize. MEA's motivation for that idea of accounting for the workforce development funds was from an ease of process perspective. We weren't focused on how to make sure the benefits stayed within the WGL service territory to a majority of its, of its impact, as much as we were making sure that we could, in our reports to the commission, demonstrate that we were doing what we thought, was sufficient to satisfy the majority term of the order.
so one question I'm not sure that you answered, and if you did, I apologize. How much of the $30 million do you expect to spend on workforce development?
A significant portion. I think that our back of the envelope calculations that we've done, it will be north of $1 million the first program year, well north of $1 million. And in subsequent program years, I think that we're going to continue to see a strong investment in Maryland's human capital, human resources. And I think that the details will be set forth in the governor's budget when it's given to the legislature on not only the workforce development funds, but the rest of the program ideas that we have for MGEF.
Okay, so you're not saying that you're going to spend $30 million on training. You're saying that you're spending $1 million in the first year, but that in the future you have other ideas, and those would be disclosed at a later point in the budget or something like that.
Commissioner Herman, that is correct. The order specifically sets forth matching grants for LDCs as one possibility, but it's not limited thereto. And we've been looking at a number of policy programs that we've come up with ourselves and that the LDCs have offered as a means for helping to expand natural gas here in Maryland. And that the order offers guidance there on what the commission was interested in seeing as well. So we're workforce expansion will not be $30 million.
Okay, that's where I was sort of,
Yeah.
when you said I'm spending a significant amount, and I'm thinking, are you building a new building or what's going on? Because
Correct.
$30 million is a lot of money.
It's a lot of money.
For workforce development, and so I was a little confused. But now you're making me feel a little more comfortable that it's not, it's your first step, and that there will be presumably significant expenditures in pipe in the ground in the future. That's your plan.
Absolutely.
Okay.
We are very focused on making sure that this expansion happens safely. We're also very focused on making sure that our LDCs don't have exorbitant commodities costs, that matching grants will be a part of that, a way that kayak costs and other incentives can be offered to help sign new customers up in a manner that meets the economic tests set forth in the tariff agreements that these companies have.
Right.
It's exciting stuff. We've enjoyed it very much, and we're looking forward to sharing more details as we flesh them out.
Thank you, Mr. Mallory. That's very helpful.
Thank you, Commissioner Herman. I appreciate the opportunity.
So what did you mean when you said significant investments in Maryland's human resources going forward when talking about the budget dollars?
Commissioner O'Donnell, thank you. We anticipate spending millions of dollars in the first 2 to 3 program years on human resource development. Training, yes, sir.
Okay, so several millions of dollars in the first several years. Give me a ballpark. What are we talking about here?
Around $3.5 million, $3.5 to $4 million over the life of the program, which we're anticipating, hopefully being about a 10-year span in congruence with the $70 million 10A commitment.
Okay. So that gives me a sense of what we're talking about here. And look, I love DLLR. It's led by a very capable secretary. Secretary Schultz is doing a wonderful job there, and I love the MEA, of course, and Dr. Tung and all the staff there at MEA are doing a good job. So this is not about that for me. I think the administration is doing a very, very good job at workforce development for the state of Maryland. But this has a little different flavor for me, of course, as you might imagine. Having played an instrumental role with my colleagues in developing the conditions and modifications to the conditions, I want to probe on that a little bit. So condition 52 is the MFN condition, and when it came in, it said that if X is larger than Y, and I'm not going to read the whole thing, but the operative part was MFN dollars will be added for Maryland natural gas expansion programs and county energy distribution related customers or educational programs, right? That's how it came in. We modified a lot of these things. We modified conditions to take care of certain C&I customers and our friends in the DOD and federal government. We modified our conditions to not take care of, it's the wrong word, to address the concerns of counties, small and large, in the service territories. We changed a lot of things, and we changed this one too. And so as it came in, it said, for Maryland natural gas expansion programs and county energy distribution related customer or education programs, and we took that county energy distribution related customer or educational programs out, and it just says now as approved for Maryland natural gas expansion programs. That's a significant change. We took the education piece out. So certainly for MFN dollars, we did not want that going to education programs. But you're proposing to use these monies for education programs. Help me reconcile that.
I'm happy to do so, Commissioner O'Donnell, and that's a great illustration. It was our understanding that that language regarding educational programs was focused more on outreach and how to inform energy consumers in Maryland about what efficiencies natural gas can offer over, baseboard electric, heat pump electric. I tend to think more residential than commercial. And we view that as very separate and distinct from developing workforce assets to have the skill, capability, and jumping off point in terms of making a market for their labor and the demand for that labor to get energy infrastructure in the ground and deployed throughout Maryland statewide and within the service area. We, of course, defer to the Commission's better judgment on that and how the Commission read that language and what the Commission intended in the language of its order.
I appreciate that. So the training facility you referenced as an example in Charles County is the College of Southern Maryland. Am I correct?
That is correct,
And the
Commissioner.
College of Southern Maryland runs a broad energy education program. It's an education program. We took the education program language out, so
I see the conflict, Commissioner. Yes. It was our understanding from Dollar that they were able to give welding instruction at that facility, which helps springboard off of the wind expenditures that we're making. Welding obviously is not the only skill involved in installing natural gas LDC assets.
don't misunderstand me. I'm all in favor of workforce development. It's an important part of economic development, and it's an important part of changing Maryland in a direction that we want to change it in. So it's a good thing. I'm not disputing that, but I'm not sure we wanted to do economic development as much as we wanted to do gas expansion, and we've been criticized roundly for that desire to do gas expansion. So I'm trying to figure out.
Commissioner, I want to be candid with you as well. We were very pleased with the settlement agreement that we filed with the Commission. We were beaming happy with the order that the Commission issued. If it is in the Commission's policy discretion that those funds be dedicated for infrastructure and infrastructure alone, I don't want to be the MEA staff member who asks for toast and a bread line from the Commission. We will respect and obey the Commission's order.
Okay, fair enough. Thank you.
My pleasure, sir.
Thank you. I just wanted to just go back on a couple of questions that were already asked. One is really not so much the legality, but would we be faithful to our order if we were to go off and do something that is not a natural gas expansion program? Because the way that paragraph reads, it talks about any extra dollars that go into the MFN will be spent for natural gas expansion programs. And then it's just tacked on in the last sentence of that same paragraph to be allocated in any matter that is consistent or required under this provision. And then it's under that, after we state in provision, that is consistent with the public interest. So, again, I just wanted to probe just a little bit. I mean, would we, if we suddenly do something completely different, such as, let's just go ahead and do a credit, would that be consistent, do you believe, with what we've stated already we had intended to order?
Your Honor, we don't think it's consistent with the terms of our settlement that was modified by the commission and ultimately approved in the order to do something like a rate credit or a rate offset. We think using the dollars for the gas expansion fund is most consistent with not only the overall order, but specifically provision 52. Having said that, obviously the commission does have discretion in how it implements its orders. Nevertheless, we think it's most consistent with your order to use it for gas expansion programs, which we contend, as the commission does, we believe, is in the public interest. So when we drafted that provision, certainly our intention was that it would be used for those two purposes, which the commission limited it ultimately to the one, which is gas expansion programs, which is why we think it's most effectively used in the gas expansion fund.
Okay.
Commissioner Richard, if I may illuminate a further point on that, our expert offered testimony that while a rate credit is very legally convenient to satisfy the requirements of the statute, it may not be the best energy policy. And he testified that, a residential consumer gets a credit, turns their thermostat up a little bit, and then the next month when there's no credit present, they get a little bit of sticker shock, and that he believed is not healthy for Maryland's energy market. So, we applaud the commission for putting the language in the MFN term, saying that the money should go toward Maryland natural gas expansion programs, and would like to reemphasize our experts' testimony regarding the merit of rate credits.
Very good, yeah. And I guess where I was going with that, since Mr. Grant does have some experience with this institution, the Public Service Commission, just the question of, consistency is somewhat important. I would think that if we have stated something and then we, go off on a completely different, we often state, well, I think everything we do, we intend to do it in the public interest. But if we go out and do something beyond what we've already stated we intend to do, is that somewhat perilous, I guess, to how people will read our orders in the future?
Well, consistency is always better, since, as a lawyer, we like to appeal things that we believe are inconsistent. So you're certainly on safer ground in this instance by adopting an order under this MFN, allocating those dollars for the gas expansion fund or gas expansion programs. We think that's the most consistent. Certainly that was our intent when we entered into the settlement, that we used for those purposes. And it wasn't certainly the intent when we entered into the settlement that additional dollars would be used for a rate credit in this instance in particular, because using it for a rate credit really is not going to add a tremendous amount of value to customers. $6, while every little bit counts, I'm sure we all agree with that, but certainly it's a better use, consistent with your order, and certainly consistent with the intent of our settlement with MEA and the other parties to use it for the gas expansion programs.
Great.
We would hope that you would give consideration to doing exactly that.
Right, and then for MEA, when you described throughout the course of the hearings what was entailed with the natural gas expansion program, it was quite broad. I think it included everything from assets to assistance in trying to address the economic test issues and some of the other, as I recall, training. So is that correct? Am I recalling the testimony of MEA correct from the hearing, that this was one of the envisioned uses of the fund?
That is correct, Commissioner Richard.
So your budget does reflect that, and you did say that you're not spending all $33 million in that respect.
Correct.
Okay.
Correct, Commissioner. Thank you.
Sure I heard that correctly. I guess the last question is kind of related to this last session. There seemed to be some that were concerned about the policy that was adopted by the administration on natural gas expansion, and the legislature took some actions that were heralded by folks who may not want natural gas expansion as somehow putting the brakes on what MEA and administration intend to do. Can you comment on that? Is there some risks that if we put additional funds into into natural gas expansion, that they may not get spent the way that the order intended they be spent for natural gas expansion?
Commissioner Richard, under Maryland law, that is a risk. The legislature holds the purse strings, and we may only expend programmatic dollars in a matter that has been set forth in the budget, and that budget has to be approved by the legislature. It is above my pay grade to really comment further, sir.
Okay, but as far as the interactions you've had with the legislature to date, are you concerned that the intended use from the settlement could be used for something completely different?
I'm confident that we can reach a bipartisan solution, and that the dollars can be used in a manner consistent with what the commission ordered. The commission has greater policy expertise on this than the legislature probably does. That's why the legislature delegated the authority to the commission to act in matters regulated by this section of the statute and to issue orders that control.
Great. Thank you. Those are all my questions. Do commissioners have any additional questions?
Follow-up.
Just one.
Okay, Commissioner. Okay.
Me, okay, thank you. I had a question for WGL. You are currently about a little more than 60 days after the close date for the merger. So could you give me an update on commitments 1 and 2? Have you already issued the credits to the customers?
Yes, we have.
Yes, Commissioner Linton. The credits went out in customers' bills in the September billing cycle.
Okay.
So all of the credits have been distributed to residential and non-residential customers at this time.
Okay. We have one of the proposals that we have that's been presented to us for this hearing today for use of the MFN money was to authorize a rate credit. So could you tell me what type of, based on the estimate you've already done now for I believe you said it was $6 roughly per residential customer, is there any kind of administrative cost or expense that is layered on top of that or embedded into it?
The similar method that we used to give out the initial credit in September would be redone. So every residential heating customer received a $50 credit, residential non-heating got $27. So those numbers, the $50 would become $6 approximately, and the other number would be less than half that. So we would go through the same process. So if ordered to do that, possibly in December or January, the same thing would happen. Every active customer at that point would get a $6 credit, residential heating, on their bill. So it's more an internal resources. I think our comments tried to get to the economic efficiency of giving a $3 or a $6 credit, whatever it turned out to be, to residential customers. But we've gone through that exercise, and it would be something we could do again.
Okay. Thank you.
You're welcome.
Commissioner O'Donnell.
Just to make sure I understand, based on some questions from Commissioner Richard and my previous questions, you request in your testimony, your written comments, that you're pleased to announce its plans to use the proceeds from the MFN for a workforce development program in partnership with DLLR. If we prohibit that use of MFN funds, will you simply continue your program of workforce development out of the other funds, the other $30.8 million, as planned?
That decision ultimately lies with Director Tung. I would advise against doing that. If the commission issued an order specifically saying thou shalt not use these MFN dollars for workforce development, my advice to Dr. Tung would be that we should take a hard look at whether or not workforce development should be conducted by MGEF at all.
Okay, fair enough. You have to evaluate it. I can accept that. You probably have the latitude to do it since you're already doing it, so.
I mean, these are all plans, Commissioner O'Donnell, and we are grateful for the guidance that we get from the Commission in these regards.
Okay, and the legislature didn't really take any specific action with regard to budgetary stopping of this program. Even though it was ballyhooed as such, we stopped it. All funds go through that process, and all programs go through the process of being subject to both executive submittal of the budget and the policy decisions contained therein, and the legislative modifications and conditions put on the expenditures. All state funds go through that process, not just this one, right?
That is correct, Commissioner. And Commissioner Richard, and I think you raised some very valid concerns. I would offer that we have a very effective human resource of our own when it comes to legislative affairs, and we're confident in his abilities to do the most appropriate thing.
Thank you.
Okay, thank you. And I agree that it was more the fact that it was such a prominent issue that I just wanted to again get your thoughts on your abilities to continue this, given the legislative realities that Commissioner O'Donnell points out. So, are we? Any more questions? Great. With that, thank you very much. We'll ask particularly the company to stand by if you want an opportunity at the very end to respond to any of the comments made in the last panel. We will provide that opportunity afterwards. Thank you. Okay, with that, we invite the second panel, Department of Defense, FEA, OPC, and staff to come to the table. Okay, yes, I will ask. Okay.
Okay, yeah, I know you guys. Traffic director.
Well, good afternoon. Thank you for participating today. To start with, can I ask you all to identify yourselves, and recorder also ask if you could spell your name for the record.
Sure.
Start with OPC.
Thank you, Your Honor. Joseph Cleaver on behalf of the Office of People's Counsel, JOSEPHCLEAVER.
Good afternoon. I am Emily Medlin on behalf of the United States Department of Defense and all other federal executive agencies. My name is spelled EMILYMEDLYN.
Good afternoon, Your Honors. Leslie Romine on behalf of staff, LESLIEROMINE.
Great, thank you. With that, well, why don't we go ahead and start with Ms. Bromine. Do you want to provide any comments from staff?
Thank you, Mr. Chairman. As you've heard, we do not dispute the calculation that was performed by AltaGas and WGL, so we're in agreement on that issue that seemed to take over the last hearing on the last merger, so you can breathe a sigh of relief on that. Our difference of opinion comes in the question of where the dollars from this extra MFN payment would be best spent. Staff is in the camp that we believe it should be best spent in a rate credit to customers. If you recall from the merger proceedings, staff's testimony in that proceeding was that the rate credit that was being awarded in that merger was lower than the other rate credits in comparable mergers and other mergers. So staff is maintaining its position that the rate credit is a good place to put these extra dollars so that the customers can see that money coming into their pockets. We believe that with regard to the actual settlement agreement and the order, the Commission does have discretion on where to put that money. I know you all have looked at that paragraph 52D, which does give you the ability, in staff's opinion, to put that money anywhere in your discretion where the public interest can be met. And certainly the public interest is met in augmenting the rate credit that's gone out to customers at this point. Staff did also do a calculation. We did not break it down into residential or non-residential, but the general overall rate credit that would go out to all classes is about $8.12 a month. So based on that, I don't dispute what Mr. Curran said about the residential being in the neighborhood of $6. I think it's probably a fair calculation. Staff, in its testimony, indicated that its preference for the rate credit is based on the fact that we believe there should be a direct, strong, and tangible benefit to the ratepayers on an expedited basis. And the idea of putting it into gas expansion, while not an invalid expenditure of money, is not a direct and expedited benefit that the ratepayers would see. I think we heard that some today, because not only are we not starting with actually putting pipes in the ground, we're evidently back at workforce development. So we think that the rate credit has a benefit of giving the ratepayers the benefit that they're entitled to under the statutory criteria for the merger. And it's more immediate and more direct. And that's the basis of our position, and I'd be happy to answer any questions.
Thank you. Any questions? Commissioner O'Donnell.
He's smiling.
So you heard my question of MEA and the language that we specifically put into Condition 52 that says MFN dollars in Maryland are going to go to natural gas expansion. And you seem to be saying, I know we have some latitude under the public interest standard, but it seems to be contrary to what you just said with regard to monies going to natural gas expansion, contrary to what we directed in our order.
In the order, yes, it says it is somewhat contradictory in there, but because of the way it reads, it does say that any MFN dollars required under this position shall be allocated by the Commission in any manner that's consistent with the public interest.
Understood.
And we believe that that does give you the discretion. Obviously, the ultimate decision is yours on, does it mandate that it has to go into gas expansion, or is another use of the money that's in the public interest okay? Our interpretation is that another use of the money is okay.
So from a legal standpoint, I'm not arguing that. I think that's right, but we've expressed maybe a I don't want to say a desire, but we've expressed an opinion that it should go to a certain place. Unless there's a compelling case, it should go somewhere else. And you're saying that the $6 rate credit is the compelling case.
We believe that given the amount of money that's been directed into gas expansion versus the amount of money that's been directed into rate credits in this case, that the expenditure that came out on the short end is the rate credit. And that's why we believe that the money should be directed to the rate credit. That is staff's opinion based on the record of the merger. Obviously, there are other conclusions to be drawn from the record of the merger, but that is our position based on the record of the merger.
I think you're right. The latitude exists under the public interest standard to give us latitude. I think that's absolutely correct. I don't think anybody's disputing that. But I think the spirit of Condition 52 is that any MFN monies would go to natural gas expansion programs.
And, people can disagree on that point, which is why you guys sit in the big chairs.
Okay. Thank you.
Commissioner Herman.
Ms. Romine, how do you respond to the company's argument that $6 or potentially less than $3 for non-heating customers would, I believe I heard, would cause somebody to turn their heat up? I'm not so sure I'm convinced of that one, but that would have a relatively minimal impact on a customer's bill, and that therefore it would it's better served going to gas expansion or elsewhere even.
Well, I guess whether $6 is something that's minimal to you or not depends on your financial position.
Agreed.
But I do think that the money spent on the gas expansion will not be noticed at all by the ratepayers, whereas if I get a $6 credit on my bill and I see it, I'm happy. You know, it may only be $6, but it's something, and I'm aware of the fact that I'm getting this credit, as opposed to it being directed into gas expansion where I would most likely not be aware of it.
Mm-hmm. And I'm not suggesting the commission's going to do this, so I don't want the Department of Defense to, to be concerned, to get instantly concerned. But if the commission, do you think the commission has the authority to, say, give this $3.9 million just to residential customers, for example? Do you think they should do that?
I honestly have not thought that through. My first instinct kicks in as a lawyer, so I'm not sure of the answer on that. But, if it could be argued that that was in the public interest, certainly you would have the authority to do that.
Okay.
I can't give you a better answer right now, sorry.
I appreciate that. Thank you very much.
Just, I guess, along the same kind of lines here, the order did determine that gas expansion program was in the public interest, so that is something that has been established. You would agree?
Yes.
Correct?
Yes.
Also, an outcome of the order was a fairly robust credit that was provided to residential customers, and in fact, we also, the commission, created some carve out, or actually not a carve out, but we included non-residential customer as well. And within the calculation, some of that money came from the gas expansion fund. Is that correct? Do you agree with that? In other words,
honestly don't
the
remember.
amounts requested for the gas expansion program were decreased from the request, and we increased for the credits money for non-residential customers.
I believe that's true. I haven't looked at the record lately to, that I could verify that, but I do believe it's true, and obviously you guys would know more about that.
Okay.
Yeah.
Well, just, I guess, where I'm going is the commission did agree that there should be a great credit. In fact, we went further and said that we need to also restore from the settlement rate credit for non-residential. And some of that money came out of what would have gone to gas expansion. So now we go to the condition. It states that, all right, we have if there are additional funds, it would go to gas expansion. So did you believe that there was kind of a logical thought process that may have been there in how we, structured the order, trying to balance, again, where, there'd be great credits and there'd be, a gas expansion program?
Oh, yes. We understand the commission did a tremendous balancing act when they were trying to allocate all these monies and where it should go. We agree with that. And, it's obviously all in your discretion where you should continue to put that money. So, we just believe that looking at the other merger cases that the commission has heard in the past, the Pepco Exelon, the BGE Exelon, the bigger merger cases, if you look at the dollar value of the rate credits in those cases, we believe that this rate credit was less, and therefore it should be supplemented. But I mean, it's a perfectly valid policy decision to decide that gas expansion is where the money needs to be. So.
Okay, and it was in the public interest, and
yes,
so
it is.
In a sense, would you agree that you could see this as just in the case that there were MFN dollars, that they would go to restore what was taken from the gas expansion program?
That is a possible interpretation of that section of the settlement agreement.
Okay, thank you.
Uh-huh.
Do we have any other questions? Great. We'll thank the panel. Oh, I'm sorry, Mrs. Ms. Medlin, would you like to go second?
Yes.
Apologize.
Good afternoon. DoD FEA basically echoes the same sentiments as staff. Our opinion is that the MFN dollars should go as a rate credit to all customer classes. The reason being that this would ensure a direct and tangible benefit to all customers. And our concern with the monies going, the MFN monies going to the Maryland Gas Expansion Program is one that only a majority of the money would have to go into Washington Gas's territory. So you're looking at potentially 1.9 million going outside of Washington Gas's territory if it was only a majority going in. And secondly is that the commission would have no say in where that money is going once it goes into the Maryland Gas Expansion Program. It's in MEA's discretion as to where to use those funds. I know they have stated that it would go to a workplace development program, but I think there's a missing nexus as to how all customers within Washington Gas's territory will receive a direct and tangible benefit from this training program.
All right, thank you. Any questions, commissioners? Yeah, Commissioner Linton.
Thank you. Just one question. Assuming the commission were to pursue the path that you've recommended, we've heard from Washington Gas that their proposal under that same assumption would be to distribute the money according to the allocation that was used in the settlement. Is the department comfortable with that allocation, or would you prefer something different?
Yes, Commissioner, we're comfortable with that allocation.
Okay. Thank you.
Question. Chairman, thank you. Ms. Medlin, were the agencies that you represent or your interest pleased with the changes, at least, that we made to the distribution in our order?
Absolutely, yes.
Okay, because there were some
Commissioner, we were
substantial changes that were made in your
extremely pleased
favor.
that the rate credits were reinstituted back into the non-residential classes.
Okay. All right. Thanks. Just checking.
Great. Is there no other questions, Mr. Cleaver?
Thank you, Commissioner Richard. Commissioners, Commissioners, preliminarily, I would just reference the discussion contained in our written comments regarding the appropriate allocator to use. As we acknowledged, Condition 52 says what it says. It was incorporated into the order, and the notice scheduling this proceeding also refers to Condition 52. And most importantly, following Commissioner Richards' comments at the outset today, that what's before the Commission today is the allocation of the $3.8 million. I'll simply submit on our written comments on that point. I'm happy to answer any questions that the Commission may have on it. With respect to the allocation, as the Commission knows, there's currently before it a Washington Gas stride case and a Washington Gas rate case. And while no order or decision has come down in either of those proceedings, I think it's fair to say that they will both have a rate impact on customers. We also heard testimony in the rate case from Washington Gas witness Gibson just last week or the week before that we can expect to see another rate case within the next 2 years. And then, of course, Condition 10A contained within Appendix A of the Commission's order in this case provides for an aspirational goal or amount for the company to submit, I think, up to $70 million in gas expansion projects that would be rate-based and the revenue requirement for which customers would pay. With that backdrop and with our role representing the interests of residential customers, we tried to come up with something to recommend to the Commission that also adheres to the limiting language contained within subsection D, which is that the money would be used for Maryland natural gas expansion programs. So what we have proposed in an effort to mitigate all of these rate impacts on customers that are coming from these filings and these future future gas expansion 10A proposals is to establish a reserve account that would be booked as a regulatory liability and that would be then be used to offset the revenue requirement associated with projects added pursuant to Section 10A of the order in this case. The company would be required to identify rate base additions made pursuant to 10A next time it files a rate case, to identify what the revenue requirement is associated with those, and then the amount in the reserve fund would offset those figures. If there was money left over, the process would repeat itself in the next rate case until the exhaustion of the account. We think that strikes a balance between the direct and tangible benefits to customers that have been described in past commission orders, and as my colleagues from the commission staff and the DOD just referenced, while also adhering to the limiting language in subsection D that this is to be used for natural gas expansion programs. One criticism of our proposal is that it doesn't itself promote the expansion of natural gas in the state. But the language of subsection D doesn't require something that will promote natural gas expansion. It requires for Maryland natural gas expansion programs. The applicants address our proposal and say, well, a rate credit is not a program. But Your Honors, if you refer to section 10A, in the middle of the section, the capital additions that are envisioned by the paragraph are referred to as programs. A sentence in the middle starts, "These programs, comma, which will be incorporated into Washington Gas's ongoing capital plan." If the commission had intended for the Maryland Gas Expansion Fund to be the only place where these monies could go to carry out the spirit of the provision, it could have specified that in the provision. The order does not specify that. It says Maryland Gas Expansion Programs, the exact same term used here in Section 10A. So in our view, what we proposed does adhere to the language of the order while also providing a direct benefit to ratepayers. Thank you.
Good, thank you. Commissioners have any questions? Commissioner O'Donnell.
Thank you, Mr. Chairman. Mr. Cleaver, the $70 million that you allude to in condition 10A, that still has to go through its normal prudence review, right, before it goes into rate base. Is that right?
That's right, Your Honor.
And it still would have to meet the economic tests that any expansion would have to meet, and they're pretty high bar, right? You got to have certain conversion rates and certain other criteria, right?
As they stand right now, Your Honor, of course, the paragraph 10A does provide for the possibility that those tariff provisions could change. But yes, Your Honor, I understand your point. Yes.
Okay, just making sure. But the Maryland Gas Expansion Fund doesn't have those same constrictures, right?
That's my understanding, Your Honor. Yes.
So I think that the way we originally set this up was that money would be used as leverage to get some gas expansion, which is in the public interest in Maryland moving forward, because the traditional methodologies were tough. Would you agree with that basic construct?
From comments from the bench and from reading the order, that sounds like an accurate description, Your Honor. Yes.
Okay, fair enough. Thank you, Mr. Cleaver. I appreciate it.
Thank you.
Any other questions, Commissioner Linton? Yeah, I would just ask, in addition to what Commissioner O'Donnell just raised, and the fund could also be used to, if a project didn't meet the economic test, to make up whatever the difference is to achieve that requirement. Is that correct?
I believe that was a testimony in the case, Your Honor. Yes.
Right. So is it possible just by providing the funds for the fund, the MFN for the Gas Expansion Fund, wouldn't that potentially have the same effect of what you're proposing, and that is to ensure that there is no rate impact from any kind of gas expansion?
Well, Your Honor, I agree with your question. I agree with your statement that it could be used for that purpose, to make up the difference for a project that otherwise would fail the economic test. But I don't think there's any requirement that the funds in the MGF be used for that purpose. So there are scenarios under which what Your Honor just described would be the case. but I don't think that that would necessarily be the case.
Okay, but to the answer to Commissioner O'Donnell, we're not waiving the economic test in any way from this case, right?
For purposes of, no, I don't understand anything in this case to waive the economic
Okay.
test for future gas expansion proposals.
Okay, great, thank you. If there are no other questions, thank this panel. And you can take your seats. Sorry.
Mr. Chairman,
Yes.
James McGee with Alexander and Cleaver.
Right,
on behalf
I
of
guess
Prince
we
George.
should at this point ask if is there anyone who would like to make any statements at this point, so we recognize you, Mr. McGee.
Thank you very much. As you know, the county was a key stakeholder in the process.
Oh, I'm
for the
sorry,
project.
I apologize, I forgot our court reporter. Could you identify yourself for the record, and if necessary, why don't you go ahead and spell your name as well?
Sure. James McGee, James, MC, capital Gee, with Alexander and Cleaver on behalf of Prince George's County, Maryland.
Thank you.
As I was stating, the county was a key stakeholder in this process, although we did not file any comments as it relates to the use of the MFN funds and don't take a position either way and defer to the Commission's judgment. But what compelled me to come up today was a discussion that Commissioner O'Donnell had with MEA as it relates to the workforce development program that they started to develop. And from where the county reads the order is that there are restrictions as it relates to the MFN funds. Commissioner O'Donnell is completely right. There used to be a provision in there that said that those funds could also be used for county distribution and educational programs, and that was struck. So in our view, that's not something that you could do and take the MFN funds and somehow give it to the counties for our programs. However, we think that the MGEF fund in general is much broader than where the MFN dollars would go to. And the key language there is that it can go for, MEA can use its discretion for the purpose of promoting the expansion of natural gas infrastructure. And we think the use of workforce development could indeed do that by having, whether it's a grayer workforce or whatever, ultimately we do think that that fits into that purpose. And want to make it known that it's not our view that MEA would have to scrap their workforce development program totally if they're not allowed to use MFN dollars towards that purpose. I'll take any questions you have on that.
Any questions? Great, thank you for that, for those comments. Okay, then we have Montgomery County.
Good afternoon. Lisa Brennan, LisaBrennan, on behalf of Montgomery County, Maryland. I just wanted to add, as Mr. McGee said, Montgomery County didn't file comments, but after hearing everything that everybody has said, we just do want to, we would put in our opinion that we would urge the Commission to consider either the direct rate credit or an offset, as those would, we do agree with the second panel that essentially those are the two most direct benefits for customers, and of course would meet the public interest test as they had before. Okay.
Any questions for Ms. Brennan? No.
Thank you.
Thank you very much. Does anyone else wish to be heard on this matter? If not, we'll go ahead and invite the company if you'd like to make any statements from what you've heard.
Your Honor, I don't think we have anything else to add other than what we've already presented to you in our comments. And again, unless you all have heard something today that you'd like to follow up with, I think we've addressed pretty much everything you heard from the second panel in our reply comments.
Great. Do commissioners have any follow-up with the company? If not, thank you all for coming today, and we are adjourned.